Hi, I'm Joe McCarthy, and I'm going to do a review of the four major legal systems in the world. The four major legal systems are common law, civil law, Islamic law, and socialist law. I'm going to start with common law. Common law was originally started in England and spread to other countries where they colonized and took over, such as USA, India, Ireland, Australia, all the nations pretty much that had Queen as a figurehead at one point. No country other than those have ever accepted common law, so yeah. Case histories are used in precedents on how future cases should be read. It's rarely overturned, especially in the Supreme Court level in the United States model, but it does happen time to time. It's adversarial. The judge acts more as a mediator, as opposed to, as we'll see later, the other systems where the judge is king of the castle, pretty much. Courts could strike down laws and statutes. Also, you can see in our Supreme Court, such as Heller versus D.C., where Supreme Court reversed Washington D.C.'s gun laws. Still makes use of juries way more than the other ones, and it's only because of plea bargains lately that the power of juries and judges have been toned down a bit compared to the prosecutor, which most crimes now do go to plea bargain. Civil law started in Roman times, then modified by the French and Germans about 19th century. Most of Europe and South America use it. It's the most popular system in the world. Does not rely on case history, as its statutes are what regulates the courts. So the judge pretty much has to do what the thing says, kind of like our sentencing guidelines. It's different than common law, at least in France from the book. They keep a strict privacy to an accused until it gets to the point where they think they'll be able to get a conviction on them. So that's definitely different than what we have. And their juries are usually only for extremely high profile murder, those type of cases, and it doesn't have to be unanimous, unlike common law, which it does. Islamic law, which is based on the Quran, it's prevalent in most Muslim countries. It kind of, the more modern Muslim countries usually have a hybrid of it, but it's still used. It does not use case history at all. Its decisions, it uses the judgment of the judge and its religious works. It also has three types of crime: had, qisas, and tazar. Had is what is regulated in the Quran. So, no judge, as the book says, no judge or legislature can alter them, as its punishments set out already in the thing. Qisas more like murder and assault and that type of stuff. So that's what it's used for. Eye for an eye, blood money, and final one's tazar, which is like misdemeanors, like less serious offenses, light felonies, and that's regulated by the judge. Other than sodomy, which is still considered adultery and penalty's death. Harsh punishments compared to the rest of the world, Western world. Lack of juries, but witnesses, especially in those hard cases, have a huge effect. You need witnesses to prosecute, pretty much. Defendants are innocent until proven guilty, much like at least common law. Civil law is a little bit sketchier on that part. Finally, socialist law, started in the USSR, primarily used in China, does not recognize any precedent from previous cases, and like Islamic law is adversarial and inquisitorial. So civil law is more inquisitorial, whereas common law is more adversarial, where you see in these last two, it's a bit of a mix. I found this interesting from the book. Chinese defense lawyers, at least in death cases, didn't try to acquit their clients. They just tried to mitigate the sentences and get a better deal for him. So I thought that was kind of weird. There's 3 levels of their court: the SPC, HPC, and BPC. The SPC is the Supreme People's Court. It's similar to our Supreme Court, except it's kind of like the antithesis of it, where, that's from the book, it is answerable to the Standing Committee of the Chinese Communist Party, offers advisory opinions, and does not hear cases forwarded from lower courts, which is pretty much everything different than our Supreme Court. The next one is the Higher People's Court, which is like, I would say, like a district court, like a federal district court. So pretty serious crimes, not as high up as the HPC, of course. The Intermediate People's Court is pretty much the same thing as the HPC. That'd be like a state Supreme Court in America. And finally, Basic People's Court, as the book says, is just like a regular felony court. So it's like, you know, a regular court. Okay. Oh, I also found this interesting, that they had a confession system, which is similar to American plea bargains, except they don't tell the person that they have this amount of evidence. So it's up to the person to decide whether he wants to mitigate the risk by saying, oh, wow, they have me, or go, no, they don't have anything, I'm just going to try to fight it and have my lawyer plead me down to a better thing, because he's not going to try to get me off. And some similarities and differences I found. 3 of the 4 systems, Islamic law, socialist, and civil law, seem to follow the crime control model, and are more for the collective good, which means less individual protections, as in our common law, such as the 5th Amendment, 4th Amendment, stuff like that. They also seem to have greater cooperation with the defendants. As the book said, in France, it's expected you testify against yourself if you get to that point in the trial. Whereas in America, that's never going to happen, unless you have a really bad lawyer or you're defending yourself and you don't know anything. The common law system has greater oversight. So like the Supreme Court can overturn laws, civil law it can't. It's regulated by the legislature, has no power to overturn. Same thing with Islamic law, especially in those hard crimes, and communistic law, where it's just a proxy of the government, so they're not going to overturn anything. And finally, as seen in the chapter 14 PowerPoint slides, there is increased instances of hybrid law, where they're kind of merging together. I mean, you can look at New York, and even the United States Civil Code. They are statutes, which is different than what common law pure form is supposed to be. Same thing, if you see my example, Quebec. It's French, but it's run in Canada, which is British. So they kept the civil law of the French and merged it with the British common law. So I hope you enjoyed my presentation, and I hope you learned something. Alright, have a nice day. Bye.